I'm Todd Gaziano, Executive Director of Pacific Legal Foundation's DC Center. I recently sat down with former Attorney General Ed Meese to discuss Constitution Day and Pacific Legal Foundation's role in protecting the constitutional rights of all Americans. For those of you too young to know of Ed Meese, he was a prosecutor when the newly elected Governor Ronald Reagan asked him to join his personal staff. Ed Meese later was Governor Reagan's chief of staff. He was director of President Reagan's transition team. He was a counselor to the president and an important White House staffer in the first administration, and he was the 75th Attorney General of the United States during Reagan's second administration. The talk I had with Ed also commemorates the great debate he launched in 1985 and 1986 when he was Attorney General. This is a conversation that changed the course of constitutional law. I began my conversation with Ed by reminding him of what he and Governor Reagan faced as far as constitutional interpretation was concerned. For over 150 years after the Constitution was signed in 1787, the courts and most other legal scholars interpreted the text according to its original meaning. But starting in the 1930s, the courts and legal academics began to invent constitutional theories that would depart from the plain meaning of the Constitution. They did that in order to expand the power of government. What were you all facing in the mid-1980s?
Well, for many years, as you point out, starting in the 1930s, but even the origins of this go back to those thinkers in the early part of the 20th century who were trying to expand the role of the federal government. But court decisions in the 1930s upholding parts of the so-called New Deal of Franklin Roosevelt, and then over the years, as the so-called Great Society of Lyndon Johnson and other similar moves to expand the power of the federal government were taking place, the courts abandoned, to some extent, particularly the Supreme Court from time to time, the idea of interpreting the Constitution as a guarantee of freedom by limiting the power of the federal government, and instead were allowing the federal government to expand and therefore interfere with people in their daily lives to an extent never even imagined by the founders when they put this national government together. And so it was really my speeches in the 1985, 1986 were really inspired by two things. Number one, Ronald Reagan's concern as president, and the fact that he had, in campaigning in 1980, and then when he first became president and throughout the first term, had talked about limiting the federal government to its proper domain and preserving the responsibilities and authority of the states. And it was also inspired by a very important law review article written by Robert Bork, who was then a professor in the early 1970s, which talked about the Constitution as a document that was real law and that ought to be interpreted according to what the law said. And so that was really the origin and the inspiration for the speeches that I gave to look at what had been happening, particularly in Supreme Court decisions, but also in some of the other federal courts, in which both the Constitution itself and also statutes that had been enacted by the Congress were essentially being expanded and in some cases changed completely by decisions of the Supreme Court.
Well, I'd like to turn to a couple of your statements in those speeches. The first speech you gave was to the American Bar Association in 1985, and I would like to read to you two quotes from that. And eventually, these were so controversial that eventually two sitting justices of the Supreme Court decided they had to respond and try to refute your remarks. Well, here's the first one. Quote, "Those who framed the Constitution chose their words carefully. They debated at great length the most minute points. The language they chose meant something. it is incumbent upon the court, you meant the Supreme Court by that, to determine what its meaning was. Here's the second quote. Only the sense in which the Constitution was accepted and ratified by the nation provides a solid foundation for adjudication. Any other standard suffers the defect of pouring new meaning into old words. So those were your supposedly controversial statements that somehow inspired Justices Brennan and John Paul Stevens and other so-called luminaries to try to refute your logic. Why were those controversial points?
Well, I think they were controversial because those two justices particularly, among others, had been departing from the actual meaning of the Constitution and expanding the power of the federal government by ignoring what the Constitution had to say. The Constitution was designed to be a limitation on power because the founders realized that the key to preserving freedom was to make sure that no persons and no organization, and particularly the federal government, did not become so powerful that it could oppress the people, as the English king and parliament did back in the 1600s and 1700s. And so that was why the idea of the Constitution being faithfully interpreted was critical in order to preserve the power of the people. You remember that the Declaration of Independence provides that legitimate governments derive their powers from the consent of the governed. And that's what the Constitution does. It gives certain powers, but it also limits those powers. And so when these justices who have been involved in departing from the Constitution and engaging in what we call judicial activism, and judicial activism means not just being energetic in defending the Constitution, but on the contrary, substituting for the Constitution their own political views, their own personal ideas, or their policy preferences instead of what the Constitution actually says. This is really the wrong way to carry out their responsibilities to faithfully interpret the Constitution. And that's why they were so upset, because this, in a sense, if the public understood the true role of judges and what not only did I say, but Ronald Reagan said and others, then their power to usurp the legislature or to interfere with the executive or to go beyond what the Constitution gives them the authority to do, this would be a limitation on their own power.
Absolutely. That makes perfect sense, and I'm glad that you also defined what is bad judicial activism in your last response, because we at Pacific Legal Foundation and throughout the freedom-based public interest legal movement do want judges to be active in defending the actual Constitution and the actual constitutional rights that we have. And that's why some people, I think, get away with falsely characterizing our view on that subject.
That's right. And Pacific Legal Foundation, as really the first general litigating public interest law firm of a freedom-based nature, has been so instrumental in carrying on both the doctrine and the practice of the true interpretation of the Constitution over the years since its founding in 1973.
I'd like to go back to another one of your supposedly controversial statements in one of these speeches. It was your third speech at Tulane University Law School, and the New York Times attacked you for this speech, but I understand from eyewitnesses like then law student, now Judge Bill Pryor, that no one thought what you said was controversial who was there. But let me read, here's one of those controversial statements. Quote, "The Constitution, the original document of 1787, plus its amendments, is and must be understood to be the standard against which all laws, policies, and interpretations must be measured. It is the consent of the governed with which the actions of the governors must be squared." And you explained this just a little bit ago, but to me, that suggests that the Constitution has an objective and enduring meaning that will impose a permanent restraint on the government. Is that what the New York Times was so opposed to?
Well, I think it was. The New York Times, I think, would follow the role of judges and justices who were activists in the negative sense and who don't follow the Constitution because of the policy of the paper, which has been devoted toward giving more power to the federal government. And apparently that was what they believed, that the Constitution should be stretched or even changed, if you will, by judicial act, rather than by the process of amendment, which is properly a part of the Constitution itself. In other words, if there's a reason and the people themselves, through their representatives, want to change the Constitution, that's one thing. But for unelected judges to have the power just by fiat, by faulty interpretation and by expanded interpretation beyond the actual meaning of the Constitution, to change what its provisions are, that's a way in which, as I say, the people can be oppressed, and the country can have a very different legal complexion than the founders intended.
Well, to bring us somewhat up to date, you've resoundingly won the debate, at least in some respects, about the proper role of originalism in constitutional interpretation. Textualism and originalism is now taught in almost every law school, even if some liberal professors still try to attack it. And no reasonable litigator would argue a new point about constitutional law without talking about what the original understanding was. Indeed, John McGinnis some years ago wrote that in public debates about the Constitution, everyone's an originalist. No one would admit that they don't care what the original meaning of the Constitution was. But the harder question is does that mean we don't have a lot to do at Pacific Legal Foundation to get the courts to then apply the proper understanding of the Takings Clause or the Due Process Clause as applied to overbearing environmental regulations, or the First Amendment or the Second Amendment? Does that make our job a lot easier, a little easier? How would you characterize it?
Well, I think whenever the court goes the right way and does remain true to the Constitution and its actual meaning, that is an advance. And I think the fact that law schools are talking about textualism or originalism as a part of looking at the way in which the Constitution is being administered, these are all good things. But the job certainly has not been totally completed. And we have yet often situations in which, for example, today, there's a block of 4 justices on these critical issues of constitutionalism, whether it applies to marriage, whether it applies to discrimination by schools in admissions, whether it applies to things like abortion, things like that, in which we still have justices on the court, nearly half the court at times seeming to be forgetting about the Constitution. We still have a lot of people who take different views and are not wedded to fidelity to the Constitution as it actually is. So we have a big job to do. I am happy to see, though, that the Pacific Legal Foundation has been remarkable in its ability to persuade justices to follow the Constitution, often by unanimous decisions in matters such as preserving property rights and other similar matters. Today, in many of the cases in recent terms of court, that the Pacific Legal Foundation has been successful. So I think the very fact that we still have these cases coming up is illustrative of the fact that we still have to be always vigilant. Eternal vigilance is the price of freedom, as you know, and certainly that's true in interpretations by the Supreme Court and those who are advocating before it as well.
Ed, your leadership in the freedom-based public interest legal movement is another one of your enduring legacies, and I was very fortunate to work with you for 16 years on various projects and conferences to strengthen that movement. But I think that you always had a special affinity for the Pacific Legal Foundation perhaps even beyond some of the reasons that you mentioned before about it being one of the first general public interest legal groups. And I think perhaps that was because of the example and the advice it gave other groups. What other role do you think Pacific Legal Foundation plays now and might play in the future?
Well, Pacific Legal Foundation always has been one of the strongest of the freedom-based legal organizations. But beyond that, it's been a great example to other groups, and also it's been tremendously helpful to other groups by providing ideas, providing examples of good litigating strategies and so on, and by cooperating on matters where various groups through amicus briefs and similar other ways can support each other. They've been a vital part of our legal strategy summits that the Heritage Foundation has sponsored twice each year, and they've just been a great example of leadership. But they've also provided training grounds for many of the lawyers who have gone on to either their own practices or to other practices in support of constitutional principles. And I think overall, as a leader in the freedom-based public interest law movement, PLF has been something that all of us admire and appreciate for their leadership and also for the fine principled way in which they've practiced law. This has been not only appreciated, I think, by judges in various courts throughout the country, as demonstrated by the very excellent results that they've attained as high as the Supreme Court, but also by the respect even that their opponents have had to have for the fine legal work that PLF does.
Well, we hope that we've only won 9 Supreme Court cases in a row. We hope this fall we'll win our 10th in a row before the Supreme Court. But since this is to commemorate Constitution Day, let me ask you one final question. How would you suggest we as Americans should recognize Constitution Day? How would you suggest we celebrate Constitution Day this September 17th?
Well, I think 2 things. Number one, the best way that people could celebrate the Constitution is to read the Constitution and become familiar with what it provides. And the second thing is for people to be willing to utilize respect for the Constitution and faithfulness for the Constitution as a guide when they go to the voting booth and participate in the elections that are coming up this year. Because the next president is going to have an awful lot to do with the future of the Constitution, because there is now one vacancy before the court, and who that vacancy is filled by, whether we have a constitutionalist, a person faithful to our founding document, will determine what the future of the legal system in the country is, and certainly how well the Constitution will be regarded and will be applied in the years immediately ahead of us.
Thank you, Ed. I certainly agree, and it's always a great pleasure to talk to you. Happy Constitution Day.
Thank you.
I hope you enjoyed our conversation. Like Ed Meese suggested, we should all reread the Constitution from time to time. If you want to read it, we have a copy on our website, pacificlegal.org. And if you'd like a printed copy of the Declaration of Independence and the Constitution, send us your contact information and we'll mail one to you.